Hi, my name is Adria Buchanan, and I am the Executive Director of the Fair Housing Center of Washington. In this presentation, I'll be talking about fair housing and your rights, and I'll go ahead and share my screen. All right, so our organization is in Tacoma, and we serve 23 counties across Western and Central Washington. We're essentially a civil rights organization, and so we investigate allegations of discrimination. We conduct testing on housing providers. We also perform education and outreach, and we do research and reports for municipalities on the housing market and different trends. In 2025, we answered 739 calls across our service area from folks who were having issues related to housing affordability, maintenance, displacement, or other unfair treatment. 53% of those calls resulted in clients feeling like they were being discriminated against because of a protected class. So these are folks that come to us and after listening to their story, asking them some questions, they have identified that they feel like they're being treated differently because of some aspect of their identity. Those other calls, that 47%, may be folks that have been having issues, but they don't necessarily feel like it's because of something related to who they are. And in those cases, we'll refer them to other agencies like the tenants union or a local legal aid provider or a municipality or zoning office, depending on what kind of issue they're having. 38 complaints were filed in 2025. And so you can see there's some drop off, right? So from those 739 to 38, what happened, right? So as I said, there's a handful of folks, a good handful of folks who feel like they're not being discriminated against because of who they are, because of some part of their identity. And so they're not going to file a fair housing complaint. But for those folks that do, they have strong evidence, and we've vetted their situation and feel like they have a strong enough case to file. If we don't feel like their evidence is strong enough, the individual can still file on their own. And so lots of people do file on their own. So the number of complaints that are filed with either HUD or the Washington State Human Rights Commission is much higher. But in terms of what comes from our office, that number is 38 for 2025. Individuals can also feel like they're they don't want to file a complaint because they are scared of retaliation, or maybe their housing situation has changed and so they don't have good contact information and they don't have the ability to receive mail, either email or paper mail, on a regular basis, to be able to continue in the process. They might also feel that they don't have as strong evidence, right? Or something has happened in their life where they're prioritizing something else. The complaint process and the investigative process for a fair housing complaint can be quite long. It can be at least a year or more. And so sometimes people just don't want to invest that amount of time in filing a complaint, right? It doesn't take us a year to file the complaint, but it could take up to a year to be investigated once the complaint is filed. So there are a lot of factors that go into play when it comes to filing a complaint and seeing it all the way through. And some people just don't want to make that commitment. In addition to the 38 complaints, we also helped 103 individuals to negotiate either an accommodation or a modification with their housing provider because of a disability related need. And so that's work that we're also really proud of. Sometimes individuals do try to advocate for themselves, and for whatever reason, they experience resistance or non responsiveness from the housing provider. So that's when we try to step in and work with them to get what they need. We also conducted 73 match paired tests, and then 44% of those tests we found to be positive for elements of discrimination. We tested a number of counties in 2025, and we tend to move throughout our service area. So, like I said, we serve 23, and although we get calls from all over, we tend to focus regionally in certain counties each year, and we rotate that so that we can gather really comprehensive data across our service area and understand what the practices are of the different housing providers. So, in addition to those match pair tests that I just mentioned, we also conducted 298 business practice and market reviews. And that's just additional information that we gather about the market. It could be ads that we've seen on different social media or different online providers. And that tells us a story too about what people are advertising, what policies they have, and helps us give more context to the testing that we're doing and to the data that we're gathering. All right, so when it comes to housing, there is the Fair Housing Act at the federal level. And then at the state level, you have the Washington Law Against Discrimination, as well as Landlord Tenant Code and um, Source of Income Law is enforced under Landlord Tenant Code in Washington. And we also have the Americans with Disabilities Act. And it's important um, to remember that these are distinct things because it impacts how things are enforced and how things are defined. So I'll talk a little bit later about disabilities. And one thing to remember too is that the definition of disability is more broad under the Fair Housing Act than it is under the Americans with Disabilities Act. All right, so in terms of who enforces these laws, it really just depends. It at the federal level, it's Department of Housing and Urban Development and the U.S. Department of Justice. And things change from year to year, and so sometimes enforcement isn't as great in some years as it has been in the past, or perhaps it will be in the future. At the state level, we have the Washington State Human Rights Commission. So they're the entity that investigates a lot of the complaints that we file. And then, depending on where the individual is, they may be able to file with a local office. At the federal level, we're really tasked with ensuring that people are not being discriminated against and that they're able to access and enjoy their home. And we don't want them turned away. We don't want them being treated differently or getting different terms and conditions because of their race, their color, their national origin, their disability, their sex, their familial status, or their religion. And that's at the federal level. In Washington, we have additional protections that include marital status, sexual orientation and gender identity, military or veteran status, citizenship, and immigration status. And if you live in any other area, you may have additional protections. The three types of fair housing violations that are defined under the law include differential treatment, and that is purposeful. And we see that the most. And that is when negative terms or conditions are placed on someone due to their protected class status. Disparate impact, on the other hand, is defined as being more accidental. And that's when negative terms or conditions impact a protected class as a whole. This can happen if someone tries to create a policy that they think is neutral and that they think is going to impact everyone the same. And in their attempt to be fair, they actually cause harm. So, this is one to look for when it comes to different policies that a housing provider might have, like a no criminal convictions policy, for example. That could have a disparate impact on Black and Hispanic individuals that we know tend to have more negative run-ins with law enforcement. So someone having a no criminal convictions policy, again, it may appear neutral on its face, meant to treat everyone the same, but in fact, it has disproportionately negative consequences on protected classes. Retaliation is the third type of fair housing violation, and this is punishing someone for exercising their fair housing rights or helping someone else utilize their fair housing rights. So, what is a housing provider's responsibility in upholding the law? So, the first thing is the dwellings. So, we're talking about retirement communities, summer homes, nursing homes, residence hotels, group homes, condos, co-ops, houses, apartments, and even vacant land. So, there are a number of different dwellings that apply. And so that means there are different housing providers that really are responsible for upholding the Fair Housing Act. There are transactions that also trigger fair housing laws. So it could be to rent, which includes leasing, subleasing, and letting um, otherwise grant for consideration the right to occupy a premise that's not owned by the occupant. And this can also include otherwise making unavailable or denying a dwelling. The transactions that can trigger fair housing laws include things like rental, sales, lending, the process of getting an appraisal or insurance, advertising, applications and screenings, leasing and selling, rules and regulations, program requirements, maintenance, the evictions process, and retaliation. So there are a number of transactions that trigger fair housing laws. So it's really important that as you're going through your housing journey, if at any point you're feeling like something is off and you're not being treated fairly, that you really listen to that feeling and that you start to gather evidence and you start to document your conversations and to follow up on things and to really create a paper trail because if it ends up going in a direction that you think it shouldn't have, it's good to have that documentation available. All right, so I want to talk about some of the protected classes that aren't as obvious. So at the federal level, I think we all can be in agreement about what race is and what color is, and what religion is, right? But national origin, it's important to note that you cannot discriminate against people based on where they've come from, based on where they may be going back to, based on the language that they speak or their citizenship status. It can also apply to Native Americans and to indigenous peoples. And so I think that when we talk about national origin, it's just really important to remember that you have to oftentimes provide things in multiple languages, and you have to be willing to accept documents that aren't the standard documents that you are used to accepting from someone. Not everyone needs to have a social security number. So really being open to that and thinking about what are the business necessities that you need to operate your business effectively and legally, and not playing into some of the bias that can be easy to default to. It's important to note that sex includes sexual orientation and gender identity in Washington. And so even though at the federal level there have been some uh, disruptions and some changes, if you are feeling like you're being discriminated against because of your sexual orientation or your gender identity, you can still file a complaint in Washington. All right, and then I want to talk about familial status. So this applies to households with any individual under the age of 18 living in the home, either full-time or part-time. And this includes adopted children, biological children, children whose guardians gave permission for them to be there, and people who are pregnant. So in this scenario, a property management company has a policy that only a single person can rent their studio apartments, each of which is at least 400 square feet. So why is this likely a violation of fair housing laws? Well, because of protected status, right? Because of familial status. And there could be a mother with a child. There could be someone who's pregnant. There could be um, two people that are living together and they have a child that they have permission to have in the home. There are so many scenarios in which more than one person could be living in a 400 square foot apartment. And generally, the rule is one person per bedroom plus one, right? That's what we see a lot in Washington. So if you come across a policy that is telling you how many people are allowed to live in a unit, be cautious and ask the landlord or the housing provider to verify where that information is coming from. Because really, it should be coming from the municipality and code enforcement, and it should not be the opinion of the housing provider. Okay, so we talked about a few of the protected classes. Now I'd like to get into talking about individuals with disabilities. So, under the Fair Housing Act, there are additional protections, and that is the ability to request a reasonable accommodation or a modification. An accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including common areas. A reasonable modification, on the other hand, is a structural change that's made to an existing premise occupied by a person with a disability in order to afford that person full enjoyment of the premises. So, when it comes to disabilities, the Fair Housing Act, like I said, is more broad than the Americans with Disabilities Act in that it covers individuals who have permanent disabilities and have issues with major life activities. But those disabilities could also be temporary. Maybe someone has undergone surgery and so they're temporarily unable to do these things. It also can apply to people who have a history of a disability. So there are a lot of different ways that someone could be eligible for the additional protections. If someone's disability is not obvious, then they do need to have a third party verification. And that verification can come from a lot of different people. It doesn't necessarily have to be a doctor or a medical provider. It could be a social worker, it could be a member of the clergy, it could be another confidant that is willing to um, certify that you are a person with a disability as defined by the Fair Housing Act. They know what your need is and that they have some type of relationship with you. And so the verification should have your name or the person who's requesting the accommodation's name and their contact information, confirm that they meet the definition of disability. It should specify what is the request that's being made and why that request is necessary due to the person's disability. There's really no limit to the number of requests that a person can have, but each request has to be reasonable. For example, a person could have multiple assistance animals, but that third party verification should indicate the number of animals that are needed. So, for example, a disabled resident may need an emotional support dog, an ADA service dog, written reminders for when rent is due, and a ramp built for her back porch. These are all reasonable requests. However, it's up to the housing provider to determine whether or not it is reasonable and if it's feasible. So, just because someone has requested something, it doesn't mean that it's automatically going to be granted. It really has to be a conversation. But some commonly approved RAs include things like reserved parking, written or verbal reminders to pay rent, additional time to complete paperwork, additional time to comply with notices, approval of approval of a live-in caregiver without putting them on the lease, being able to transfer units, or being able to break a lease without penalty if the environment really is no longer suitable um, for the client and for the conditions that they may be experiencing. Modifications that we've seen include things like chair lifts, ramps, and shower bars and grab bars. When it comes to reasonable modifications, who pays? Well, if it's a federally funded housing provider, they would pay. But they could deny the reasonable modification if the tenant is not disabled or the modification is not tied to the disability, or it creates an undue financial and administrative burden. The tenant would pay for the reasonable modification, but the housing provider I'm sorry, the tenant would pay for the reasonable modification if it wasn't a federally funded property. So if we're talking about a market rate property, then the tenant would pay for the modification. However, the housing provider must approve that the reasonable modification can be applied unless it's going to damage the structure. But they can also request that the modification be returned to its original state in some instances. They might also require that the tenant create an escrow account for restoration costs. let's talk a little bit more about assistance animals. We get a lot of questions about assistance animals under fair housing. So it can be nearly any type of animal or animals, and it differs from the Americans with Disabilities Act definition of service dog, right? Because under the ADA, you can only have service animals. Um, but this, under the Fair Housing Act, your animal does not have to be trained to perform a task. It can be trained by the resident and no certification is necessary. It can include emotional support, companion, and therapy animals. And it may not be allowed in businesses not covered by fair housing laws. So if you see an emotional support animal at a grocery store, that is not a covered protection under the Fair Housing Act. That's something entirely different. And so we're not suggesting that people try to apply the protections of the Fair Housing Act to situations that don't have to do with housing. In these situations, when someone is requesting an assistance animal, the housing provider must waive any pet fees, and they should also waive breed, weight, size, and age restrictions. However, they still have to legally comply with local ordinances, right? And if damage is caused by the animal, the housing provider is well within their right to assess that damage the same way that they would any other type of damage that may be caused during the tenancy. All right, so let's talk about a scenario. In this one, Morgan contacts the local housing authority to request that they accept her application for a voucher. Sam, who's a housing authority employee, informs Morgan that the deadline to apply has passed. Morgan states that they missed the deadline due to being in the hospital, plus recovery time afterwards, and asks if an exception can be made. Is this an official reasonable accommodation request? And if so, what documents does Morgan need to submit for the request? And what are legal reasons the housing authority may deny Morgan's request? So, in this scenario, Morgan contacts the housing authority and the deadline has passed, right? So, um, actually, let me back up there. Is it an official accommodation request? Yes, it is, right? She contacted them and she asked for something. And a request can be made verbally, it can be done through email, it could be through text, it could be to any representative of the housing provider. It is the housing provider's responsibility to make sure that that information gets to the appropriate party. So even though a housing provider may have a portal that they want people to submit requests through, if someone decides to call or if they decide to show up at the office and talk to the leasing agent in person, those are still considered very fair ways to make an accommodation request. And they have to be acknowledged and processed as such. So that's number one. And then what documents does Morgan need to submit? So the deadline is passed, right? And she's saying that she missed the deadline because she was in the hospital plus recovery time. So she needs a third party verification. She needs to provide evidence that she was in the hospital and that there was recovery time. But she also needs to be able to respond to allegations that she had enough time before she went into the hospital, right? So that note needs to really lay out what the timeline was and show that she was not able to complete any of the steps necessary to get that paperwork in time. And then what are the legal reasons? So even though let's say that she has all of that and she submitted all that to the housing authority, um, they could still deny it. The window for accepting applications could have simply closed. Maybe it's for legal reasons that they're not able to make that exception. Um, maybe all the vouchers have been used and they've given them all out. Maybe they're on a lottery system and not a waitlist system. Who knows what internal operations are impacting whether or not they're able to allow Morgan to have her application processed, right? And who knows, maybe they accept her application, but just because she's turned in her application doesn't mean that she's automatically qualified for the housing. So there are a number of scenarios in which the housing provider could still deny the request, but the point is that you can make a request through any means, and that you need to still provide information and verification to support what it is that you're requesting. And you have to be willing to understand that not everything is going to go your way, but it's really important that each side is open to alternatives. So maybe it's not the issue of the application, but maybe it's wanting a ramp put in, or maybe it's wanting hardwood floors put in. There are scenarios in which the housing provider can't meet you exactly where you're at, but they may be able to suggest alternatives that are perhaps cheaper, but still have the same impact and still help the client to mitigate the symptoms of a disability. So, those are all things that I want you to keep in mind as you think about the reasonable accommodation and modification process. All right, so we're coming to the end here. So, what can we do in the future? Um, in addition to just creating more inclusive communities and really just challenging things that you see in the marketplace that you don't believe to be right, there are other things that we can do. So, universal design is a concept and it's a design strategy that we are encouraging people to start to employ and to incentivize. We want developers to be doing more of this kind of work, not only so that we can meet the needs of individuals with disabilities, but so that we can also create spaces where people can age in place. We have an aging population, and we also have people from all different walks of life, all different types of needs, not just disability related, but intellectually related as well, and developmentally. And so we want to create spaces that are going to be more inclusive and have adaptable use. That way, we don't have to worry so much about whether or not an ADA specific unit is available, because all future units can be used by a variety of individuals with a variety of needs. So, again, universal design is something that we're really encouraging folks to learn more about and to advocate for in their communities. And then we also want to introduce this idea of rental escrow accounts. It's not new, but it would be new in Washington. And really, it's this process in which someone who is unhappy with their housing situation can still opt to live there and pay the rent, but they don't have to pay it directly to the landlord. So, say someone is having some maintenance issues and they've had maintenance issues for a long time that aren't being addressed. Instead of not paying their rent and withholding it and then being subject to possible eviction for non-payment, they can take the rent that they would normally pay to the landlord, put it into a third-party escrow account, and cite what things need to be fixed. Then the housing provider can get that list, and then they can show, once they have remediated the issues, they can take that to code enforcement. Code enforcement can sign off on it, and then those funds that have been held in escrow can be released to the landlord. We think that this would really help cut down on the number of issues that we receive, and also give tenants a way to elect um, and to take some action against their housing provider without having a lot of really harsh legal ramifications. So we think that this could be a good option to satisfy individuals who are having issues, but don't necessarily want to file a fair housing complaint. Um, so if that's something that you want to learn more about, just let us know. So in this presentation, what I've really tried to do is just share with you what your rights and responsibilities are under the Fair Housing Act. So if you feel like you're being discriminated against for any reason that has to do with some aspect of your identity, give us a call. We will ask you about your situation, we'll collect some basic information from you, and we'll really help you to think through what you've experienced and to organize the evidence that you have. And we will really walk you through the process. And like I said, it could take at least a year, but we're there with you every step of the way. So we will file. It will be assigned an investigator at the state level. And then, as that investigator is looking through your documents, talking with witnesses, asking for information from the other party, from the housing provider, we will be there with you along the way. So I don't want you to feel like you contact us and then you're kind of on your own. Like we're here to help you and to support you throughout that process. One of the things that we do too is to help our clients think about what would make them whole. You know, a lot of folks go through really challenging situations and they lose a lot in the process, and it shouldn't be that way. And so our job also is to help figure out, how do we get you back whole? How do we put you in a situation where you can move forward with some dignity and with some grace? So if you're experiencing something and you're not quite sure what it is, you're not quite sure how to process it, give us a call. So you can contact us. Um, I'll share the phone number. So it's 253-274-9523. And you can visit our website at fhcwashington.org, and you can email us at info@fhcwashington.org. We do training and outreach, we do investigations, and we do policy reviews. If you're interested in being a tester, and helping us to run those tests throughout our service area, we we are always looking for testers from all walks of life. And that is a position that we pay for. It is kind of a seasonal as needed thing, but we have a lot of testers that have been with us for a long time and really take a lot of pride in the work that they do for us and help us to really move the needle in a lot of ways, and to share with people what's actually happening in the housing world. So, again, feel free to contact us if it's someone that you're working with. So maybe it's not your particular situation, but say if you're a social worker, or you've got a friend or a family member who's going through something, you can certainly contact us. They can contact us. If you're just looking for some basic ideas and some brainstorming about how to tackle a situation, we're happy to be thought partners for you as well. So don't feel like you have to contact us only when you want to file a complaint. Like I said, we got 739 calls last year, and we answered every one of them. So we're always here to help. We want to be a partner in solving these issues and to create more inclusive communities. So thank you for your time, and we look forward to hearing from you.